Hello everyone, this is going to be a legal dictation. Get ready, start. Thus, the position with regard to section 34 IPC is crystal clear. Stop. The existence of common intention is a question of fact. Stop. Since intention is a state of mind, it is therefore very difficult to get direct proof of common intention. Stop. Therefore, courts in most cases have to infer the intention from the act or conduct of the accused or other relevant circumstances of the case. Stop. However, an interference as to the common intention shall not be readily drawn, and the criminal liability can arise only when such interference can be drawn with a certain degree of assurance. Stop para. With the aforesaid legal position in mind, we have considered the submission made by the counsel for the parties and also scrutinized the evidence available on record before us. Stop. On a perusal of the evidence before us, we find that all the prosecution witnesses except the official witnesses, namely PW8, disowned the prosecution case. Stop. However, what is clearly established from the evidence of prosecution witnesses is that acid was thrown over the deceased on the night, which caused blisters and rashes on her body and later led to her death. Stop. This fact finds corroboration in the dying declaration given by the deceased, wherein the deceased has categorically stated that on the night, accused number 1 and the appellant had entered into her house and poured a watery substance over her from the pot, which the accused number 1 was carrying in his hand. Stop. The dying declaration given by the deceased comes as an important piece of evidence, as it throws light on the role played by each of the accused persons at the time of the incident. Stop. After a careful reading of the dying declaration, what comes out to the force is that it was accused number 1 who had carried a vessel containing the acid and who had actually thrown the acid on the deceased. Stop. The deceased in her dying declaration had attributed the act of carrying the vessel containing the acid and throwing the contents thereof on her. Stop. From the dying declaration as on record before us, it is clearly established that the appellant was present at the time of the incident. Stop. However, what needs to be ascertained is whether the appellant herein shared an intention common with the accused number 1, so that he may be convicted under section 302 IPC by invoking the aid of section 34 IPC. Stop para. To find answer to this question, we need to revert back to the dying declaration of the deceased. Stop. In her dying declaration, the deceased has imputed the acts of entry into her house and physical presence at the time of the incident to the appellant without anything more. Stop. No other overt act, save as mentioned above, has been imputed to the appellant by the deceased. Stop. It has also not come in evidence before us that the appellant tried to gag her mouth or overpower the deceased in any other manner so as to facilitate the pouring of acid on her by the accused number 1. Stop.